Hello, I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines, where we're pleased to have on the show 19th Judicial District Trial Court Judge Tim Kelley. Judge Kelley is going to talk to us about why he's running to be on the Louisiana Supreme Court, and he's going to talk about the difference for being a trial court judge, where you actually see live human beings and hear the testimony and see the evidence, and that compared to the role of a Louisiana Supreme Court justice. So join us on the next Legal Lines with Judge Tim Kelley. Hello, I'm Locke Meredith, and I'd like to thank you on behalf of myself, Sean Fagan, and Corey Ogeron, and our entire staff for letting us come into your homes for the last 10 years via Legal Lines. We hope that you've come to a greater understanding of how the law works and how the government works for you. So from all of us, thank you. Hello, welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have on the show today Judge Tim Kelley. He's a judge on the 19th Judicial District Court. Judge, thank you for being on the show again.
Locke, happy to be here.
Well, you're getting ready to make a run for the Louisiana Supreme Court.
That's right.
So I understand it. And I wanted to discuss with you the difference between what you've done for the last, 16 years at the trial court level with what you would be doing at the Supreme Court for the state of Louisiana, and kind of the difference between the roles. Sure. But before we dive into that, tell the folks a little bit about you real quick. Just educational background, employment.
Well, I went to Cornell University. That's
engineering, right?
In engineering, that's right. And
that's some hard stuff.
I thought it was pretty tough, but I got through it. When I got out, I started working for the Department of Highways then. It's now called the Department of Transportation and Development, designing bridges. I did that for a couple of years. Then I worked as a consulting engineer with Vince Fort at Fort and Tablata for a couple more years, until I had spent the requisite time to be able to take the national exam to become licensed as a professional engineer. Passed that exam, got licensed, and a bunch of contracts immediately hit my desk, because now I could sign contracts. Found myself much more interested in the contractual side of it and the legal side of it than the design side of it. So I went to law school.
So that was the first exposure, I guess, to the whole profession.
It really was.
And that had to be quite a commitment to go from, since you'd already gotten the certifications, to basically almost turn the boat around.
Yeah, it was. A lot of people thought I was crazy, to tell you the truth. But you know, my dad who's basically formed what I am in my life, has always stressed that follow what you think is the right thing. Work as hard as you can to attain it. If you fall down, get up and try again. I was fortunate enough to do well in law school, and Justice Fred Blanche at the Louisiana Supreme Court asked me to come down and law clerk with him. So I did that for a year. So I'm very familiar with what goes on down there.
Excellent.
And how it works. When I got done with that, I went to work for a large law firm in New Orleans called Phelps Dunbar. When they opened up a Baton Rouge office, I got a chance to come back up to Baton Rouge.
What did you handle for Phelps? What type of work?
I did construction law, commercial litigation, environmental law.
Which met with the criteria and certifications of engineering.
Correct. I kind of got the chance to put both of those together. I was fortunate enough to make partner in 4 years on what was basically a 6-year track.
Yeah, those are one of the big boy firms.
Yeah, and after a few years, I decided that I would go out on my own. Got a partner, David Gary, and we had a firm for a while, did very well. And in 1996, several seats came open on the 19th JDC, and I decided, well, you know what? Maybe somebody who doesn't always dream of being a judge, who would rather try and help people, can take one term out of their law profession, which is a 6-year term, and give it back to the community. Well, guess what? I was lucky enough to win. I ended up falling in love with doing what I was doing, because it was truth, justice, and the American way.
Well, and it's different.
I didn't have to take a side. I didn't feel guilty about beating somebody because I didn't have a good attorney on the other side. You always do what's right for the people. You follow the law, and you can go home at night and you can sleep well.
Tell the folks a little bit about the clerking, because with the Supreme Court Justice Blanche, because that does give you a unique perspective, having already kind of been in the mix, so to speak.
Absolutely. One of the things that I think is interesting is most people don't understand the tremendous volume of work that a Supreme Court justice has.
Truly. I mean, we've had Chief Justice Kimball, and
it's almost a 24/7 job.
Yeah.
There's really no weekends off. When you're going to conferences and things, you generally have somebody driving you so you can work in the car. The caseload is extremely heavy because if you think about it, there's only 7 justices for the whole state. Everyone who thinks that they got a wrong decision in the lower courts is going to apply to the Supreme Court and ask them to listen to their case. And of course, the Supreme Court is almost exclusively a discretionary court.
Right.
There are some mandatory things that they must hear, such as death penalty cases they must hear, but most of it's discretionary. And in order to determine whether or not to hear a case, they're going to have to read the briefs of both sides that are very thorough. They're going to have to look at the record of each side. And they take cases from the entire state rather than from a particular region.
Yeah, I think you mentioned there's one Supreme Court with for the state of Louisiana with 7 justices. You have, I think it's 42 trial courts.
That's right.
That feed up through the 5 appellate courts. And then, so it's like a giant funnel where all these cases are coming down, and it ultimately can land in the lap of the Supreme Court. Of course, there's no way they can resolve all those issues, and they don't have to.
Well, that's
because
right.
You said it's a discretionary supervisory jurisdiction for most
And there really is a criteria by which the Supreme Court determines whether or not to take a case. They'll focus on several different things. Number one, if there's a conflict between 2 different circuit courts of appeal, they'll have to resolve that conflict, and that will be a reason for them to take the case.
Let's discuss an example, because I don't think maybe everybody understands how does that happen. How can one person have the same facts of a case, let's say they get rear-ended by an 18-wheeler, and it happens over here, and one court awards damages and one court doesn't, and so they're going, wait a minute, justice isn't fair.
Well, here's an example that most people could be able to relate to. You get into an accident and you have an insurance policy, and that insurance policy has certain exclusions in it, and it covers certain things, but insurance companies, being a business, try and narrow down what they're required to
reduce their exposure.
Exactly. One circuit may read that exclusionary language in a policy very, very narrowly, and one may read it very broadly. And so you can get 2 different results on the same fact
So in
issue.
essence, one court says there is going to be insurance coverage and pay insurance, and one court may say, no, the policy doesn't cover that set of circumstances.
Exactly right.
You're out.
And so you need the Supreme Court to make a decision as to how the courts are to interpret certain language in these types of contracts. That's one example of something I think most people can understand, because we all know that we have to pay for our insurance, and we understand.
And I think it's an important point that the Supreme Court is different from any other court that's in the state of Louisiana for that very reason. When they say something, when they render a decision, that's it. On a decision on an issue, that's it.
There's nowhere else to go. That is the end of it.
Then all the other courts are supposed to follow what the Supreme Court did, and it's called precedent.
That's correct. And theoretically, after several years, there should be no more conflicts between the courts. But because each judge is a little different, interprets things a little different, and sometimes the language from the Supreme Court can be fact specific, you will end up with conflicts in the court. What you want a Supreme Court decision to do is be very clear as to how certain things are to be applied, how a law is to be interpreted, and make it very direct and very clear so that there can be no confusion in the lower courts as to what they should and shouldn't do with a certain situation.
And because the purpose of the Supreme Court is to maintain consistency. They want justice for person A to be the same justice for person B.
Absolutely, absolutely. When you get to that level, you want to make sure that across their entire state, everyone knows what the rules are, and everyone understands whether or not they have a valid claim or not, based upon what the Supreme Court has said our precedent is for this type of situation.
Another circumstance under which the Supreme Court may decide to listen to an appeal is when there is a judgment rendered by the trial or appellate court, and the Supreme Court says that is not properly interpreting the law or the Constitution. Let's discuss that on the next segment. This is Locke Meredith with Legal Lines. Judge Tim Kelley will be right back. Hello, I'm Locke Meredith, and I'd like to thank you on behalf of myself, Sean Fagan, and Corey Ogeron, and our entire staff for letting us come into your homes for the last 10 years via Legal Lines. We hope that you've come to a greater understanding of how the law works and how the government works for you. So from all of us, thank you. Welcome back to Legal Lines. I'm Locke Meredith, and again, we're pleased to have on the show today Tim Kelley. He's a judge on the 19th Judicial District Court, and he's decided to run for the Louisiana Supreme Court. Judge, we were talking about the difference between the Louisiana Supreme Court and the 5 appellate courts that are below the Supreme Court, and then the 42 trial courts. And we were discussing that the Supreme Court has discretion. They can decide whether or not they even want to listen to an appeal. We discussed that there are 5 different type of criteria they decide as to whether or not they're going to listen. And the second one we were discussing was the Supreme Court decides that an appellate court in a case is not properly interpreting the law or the Constitution, and that could be federal law, federal Constitution, or state law or Constitution. Explain that to the folks.
Well, you have to go back to basic civics. Remember how our government is set up. We have a federal system, we have a state system, and both of them track very closely to each other on the judicial side, where you have trial courts. Those are called our district courts. That's where you go in and you present your evidence and a decision is made.
And that's where live human beings come in,
exactly,
and evidence introduced and exhibits and all that. But that's different from what happens at the appellate level.
That's right. At the appellate level, what happens is if at the district court you're dissatisfied with the result, you have a right to appeal to a court of appeals. And those are the 5 circuit courts that we have. They do not take any evidence at all. No one testifies. They look at the record, and you have a direct right of appeal. They have to listen to your case after there's a final judgment. Then there's the Supreme Court. The Supreme Court, it's discretionary whether they take up a case or not. They're not required to listen to your case. One of the ways that they will take their case, or one of the reasons why they will take your case, is if after a review they determine that our Constitution, either our federal Constitution or our state Constitution, has been misapplied by the lower courts or misinterpreted, and it needs clarification. And they will take that case up and they will very carefully walk through what it should have been and how it should be interpreted in the future. And remember, we have 2 separate constitutions.
Right.
We have one for federal. We have one for our federal government, and then Louisiana has its own state constitution. Remember that all rights that are not given to the government, to the federal government, are maintained by the states. So the states have to have a way of administering their laws and taking care of their people, and that's why we have a separate state judicial system, a separate Supreme Court.
It's interesting too, Judge, because the Louisiana Supreme Court is the sole court that gets to decide what our Louisiana Constitution means and how it's to be interpreted. The United States federal court can't do that.
That's absolutely correct.
So it's a very powerful court.
Absolutely. They have no say whatsoever in how we interpret our laws and our Constitution. Interestingly, the state Supreme Court may look at federal laws for interpretive purposes as how they apply and interact with our state laws. On the federal side, you may get the federal district court asking the state Supreme Court, how do you interpret your law so that we can apply it to a case that we're supposed to apply Louisiana law in our federal case over here.
So people understand. So at times, the plaintiff or the defendant can say, we don't want to litigate in the state courts, we're going to litigate in the federal courts. And if it involves an issue of the state constitution, the federal judges can't just decide what they want to decide.
That's correct.
And it's called a certification.
Right. They ask for a certification from the Supreme Court, Louisiana Supreme Court, who then provides a written opinion saying this is how the law must be applied in Louisiana and how you must apply it in your federal case.
And I think people need to really understand how important it is, because the very fact that every single state, every one of the 50 states has a Supreme Court, and they have that power. And this is reflective of the fact that the United States Constitution did only have certain enumerated powers given to the federal government. Whatever wasn't enumerated in the U.S. Constitution, as you stated, the states keep, and they decide what they want to do.
Absolutely correct. Remember when we set up our country, part of what we did is we wanted to say we no longer want someone who has total control over us and tells us what we must do and what we must not do.
No kings.
So we will only provide or give up and provide to the U.S. government, the federal government, those rights that we know are needed to be governed by all people. But local issues such as state issues and things that are very close to how we live our life, we're not going to let the federal government tell us what to do, so those rights are retained to the states, and therefore they have to be administered through our separate court system, and that's what we do.
And then kind of the other side of the coin would be if our state courts are interpreting federal law, because likewise a plaintiff or a defendant can decide they don't want to litigate the matter necessarily in federal court. They have a way to litigate in state courts. Then the Louisiana Supreme Court would have to look to the federal law to guide it.
That's correct, and quite often that occurs very, very often in discrimination cases. What they're called 1983 actions is what they're called because it falls under the U.S. Code and federal law. Louisiana has tracking law on discrimination, similar laws to discrimination, but individuals in the state of Louisiana may sue under federal statutes in state court. And so the state court, and especially the Supreme Court, must decide how they must be applied through our court system and how the rights of the people are to be protected through that.
Now, a third kind of criteria that may help the Supreme Court decide to take an appeal would be that they determine that this is an issue involving law, that there needs to be a pretty concise, immediate determination of what it means and how it's to be applied. It's more of almost like a policy position taken by the court. Explain that to the folks.
Well, there are certain issues. Let's take, for instance, how the Constitution would deal with our education system. And it's provided for in the Constitution, and yet it's subject to some interpretation. The Supreme Court is the one who determines, as a matter of state policy, how it should be interpreted and applied. That takes place with regard to education issues, with regard to taxation issues, regulatory matters for toxic torts and things like that. Because of state policy, the Supreme Court examines the language and makes a determination as to what should and shouldn't be provided.
It's interesting, you know, a lot of people complain about judges legislating from the bench. You'll hear that term, and that's because sometimes it will appear that the courts are doing things or almost legislating from the bench.
Right.
And really what the courts are supposed to be doing, and oftentimes Chief Justice Kitty Kimball in fact confirmed that they look at the legislative intent when the law was passed, and then they try and apply the law based on what the legislative intent was. But if the legislation is not real clear, they got to fill in the gaps.
Well, that's true. And one of the things that we all have to keep in mind is we have many, many, many laws. They're passed every year by the legislature. Some of them are not artfully crafted. Some of them, quite frankly...
Well, politics doesn't always result in the
That's right, because politics is a matter of compromise,
always.
Usually
Right.
in legislature. That's why they say you don't want to watch sausage being made, you don't want to watch laws
Not
being
pretty.
made. It's just not a pretty thing. Well, the final result is that hot dog may taste pretty good, but you can't quite tell what's in it. Same thing with our laws. On the face, they may seem to say something, but when you examine the clear language of them, they may not, in fact, state the intent of what it was supposed to do. And that's what the Supreme Court has to determine, is really what was meant by it. And many, many times, our laws are not clear. When our laws are clear, the courts are supposed to follow them to the letter.
All right, well, we'll continue this on the next segment. This is Locke Meredith with Legal Lines. Judge Tim Kelley will be right back. Hello, I'm Locke Meredith, and I'd like to thank you on behalf of myself, Sean Fagan, and Corey Ogeron, and our entire staff for letting us come into your homes for the last 10 years via Legal Lines. We hope that you've come to a greater understanding of how the law works and how the government works for you. So from all of us, thank you. Welcome back to Legal Lines. I'm Locke Meredith, and again, pleased to have on the show today Judge Tim Kelley. He's a judge on the 19th Judicial District Court, and he's decided to run for the Louisiana Supreme Court. Judge, we were talking about the 5 criteria that the Louisiana Supreme Court uses to decide whether or not they want to even hear an appeal, because they don't have to hear all appeals.
That's right.
Let's talk about the 4th criteria. and that is that they've decided that they don't like the precedent, the rulings that have been given by a previous Supreme Court. Explain that to the folks.
Well, as we know, things happen throughout history that change circumstances. We have had U.S. Supreme Court decisions in the past that upheld segregation.
Right.
Obviously, as we've grown and as a country and learned and matured, we look back at some of the precedents that have been set by our Supreme Court and we realize that they may not have been quite right. Our Louisiana Supreme Court has the ability and the authority to go back and look and see if, in fact, they were wrong in the past, or if they misapplied the law in the past, or if their policies in the past do not fit circumstances that are our reality in life today. And they can go back and overturn what they've done in the past. So many times you'll see appeals to the Supreme Court, writs to the Supreme Court, where people are asking them to go revisit what they've done in the past because they believe that it wasn't properly decided. And if a good legal argument, new legal argument is given, the Supreme Court in many instances does go back and change what they've done in the past.
And let's discuss how that can even happen, because for one thing that folks need to understand is that we have 7 justices, and it doesn't require unanimous opinion. That is, every single justice agrees with the opinion that's written by the court, how it decides the case. It's just a majority rule.
Exactly right. There's 7 justices, at least 4 have to agree.
And so there might have been 4 that agreed with the position 50 years ago, and now it comes up again because the Supreme Court has decided we need to address this again. And all of a sudden, there's no longer 4, there's less than 4.
Correct. With the passage of time comes perspective, and perspectives change as we go through our society and through our life. And now there may be 4 that are for something, whereas 3 were for it before, and weren't able to pass that law or give that precedent.
It's interesting too, because our country feels so divided right now. Everybody's defined as liberal or conservative, and whether or not you support freedom versus big government and all that stuff.
Right.
And so, because, example, we've had discussions about the United States Supreme Court, and it seems to be split between 4 liberal, what people would call liberal justices, and 4 conservative, and you got a swing vote in there.
That's correct.
And we can have the same circumstance here.
Well, actually, this particular election that's coming up is exactly that situation. We have 3 perceived liberal justices. We have 3 perceived conservative justices. Whether they are or whether they're not, that's perception. And so this particular seat that's coming up will be what you call the swing vote as to whether the court moves to a liberal bent on how it interprets the law or moves to a conservative bent on how it interprets the law. And that's how sometimes past precedents get changed if there's a change in the court. And there will be a change in the court on this election.
And of course, the judge or justice in this case is not supposed to be deciding issues based on their conservative or liberal philosophy.
That's right.
But a lot of people will say, well, I can discern what they are by looking at their past decisions, whether they were on the trial court or previous appellate courts or whatever. And so that's one of the issues that, frankly, is as you've indicated, a big issue here in Louisiana.
Absolutely. It's a critical issue. And the difficulty with a judicial race, quite frankly, is unlike a case where someone's running for the Senate or running for a representative where they have a voting record. There's not a quote-unquote voting record open to the public for judges on their decisions. The public, if it wants to, can go look at every decision that's made at the appellate level and can get guidance from their friends who happen to be attorneys as to how or what type of bent a judge may have. At the end of the day, the judge is supposed to strictly construe and follow the law. But as we know, if the law is unclear in some areas, human beings being what they are, there will be different opinions as to how it should be applied. Thus, whether someone seems to be more liberal than another or more conservative than another becomes important at a certain stage, especially when the law itself or the policy that's being considered is changing or subject to interpretation.
And it's interesting because in Louisiana, we elect our justices. Not all the states, as I understand it, appoint their justices.
That's right.
And so there's an element of politics that enters into this whole thing, where you've got to seek the support of different groups and different folks, and so there's this kind of strain almost to the system, but yet it makes the justices accountable.
Absolutely. I mean, you said it as well as I could have said it. The scrutiny that takes place by the public has to do with, it's aired during these election times, because quite frankly, when there's not an election up, our public doesn't pay much attention to the judiciary. It really doesn't. But now they can focus on it. Now they can look and see and determine from the history of what these judges have and haven't been doing, how to make their decision on this.
And it's interesting, I know that I believe we now have video in the arguments at the Supreme Court, which is interesting. You can kind of watch the process and you can see how folks are analyzing it, the justices are analyzing it.
Yeah, we don't have that in Louisiana trial courts or appellate courts. If we did, it would probably make it a little easier on the public. I mean, everybody likes court TV, frankly, let's face it. But we don't have it in Louisiana, and so it's difficult for the voting public to understand who these judges are. And
the consequences of this election are huge, because not only are we dealing with the Supreme Court, but we also have the fact that the justices' term on the Supreme Court is 10 years.
That's right.
I mean, it's 6 years at the appellate level and at the trial level, I believe.
Well, the appellate level, trial level is 6 years, appellate courts are 10 years, Supreme Court is 10 years.
Okay,
the one thing we have to remember is that the justices not only rule on cases and determine which cases to take, but they are the administrators for the entire court system.
That's right.
And so they are the ones that direct how our justice system, in what direction it will move, and how it will either grow or how it will become more defined, or how we move our cases through the system is very much defined by what our Supreme Court sets forth as the rules that all judges must live by. And we have a set of rules that we must live by that's promulgated by the Supreme Court.
And I think I was reading that there's about 5,000 cases annually that come in. They write about 150, max 200 opinions a year, but then they're administering almost 600 judges, as we mentioned previously, 5 appellate courts, 42 trial courts, and then you've got a bunch of city courts and parish courts. It's a huge monolith that they operate.
If this is a corporation, you have to think of the Supreme Court as its board of directors. They have to make the policy decisions, not just on the law, but on how that company is going to work and how it's going to function. And basically, they have to direct what the lower courts will and won't do.
Judge, thank you so much for being on Legal Lines. We appreciate it. And this has been Locke Meredith with Legal Lines with Judge Tim Kelley. Thank you for being with us today.